Good morning to everyone. This is Professor Olavo Caiuby recording from São Paulo, Brazil. I'm here at my studio. This daytime here, so good morning or afternoon or evening, wherever you are. And I would like, first of all, to thank my good friend, Nicolas Merloni, for inviting me to speak today at the World Constitution Day. Let me just introduce myself very briefly. I am an attorney licensed in São Paulo and practicing international and business law in São Paulo. I also do hold an LLM in U.S. International Law from the University of Miami School of Law. In my LLM, I had the opportunity to focus in constitutional law, and I did set for the New York bar exam in 2012. I moved back to Brazil and got a master's degree in political science from the Federal University of Pará in the north of Brazil. And currently, I am a PhD candidate in international public law. I teach international law, constitutional law, and I also teach legal English. Currently, I teach a course in American Legal English for the Legal English Institute, and I also do Portuguese English translations. So in a nutshell, this is more or less the overview of my qualifications. And today we're going to talk a little bit about judicial activism and have a overview of the federal of the U.S. Constitution, first of all, comparing with the 1988 Brazilian Constitution. So let me just quickly speak about the U.S. Constitution, and I'm going to share some interesting material on that. Let me just see where is this. Just a second, the split of a second for us to. Let me just stop recording. I'll be right back. Okay, so I just found my slides, my PDF slides, PowerPoint PDF slides. So this is the presentation that I have on the U.S. Constitution. And as I mentioned, I do hold an LLM, U.S. and Transnational Law from the University of Miami, among other things. And currently I have my own consulting firm, OCD Consulting. So feel free to contact me. I'm going to leave my information at the end of this presentation. So the American Constitution is very interesting to understand or to notice that is a Constitution from 1787. So it's a very ancient, old Constitution. It's a Constitution that was drafted in 1787, and the independence was declared on July 4th, 1776. The Constitution is a short Constitution. It has one preamble, 7 articles, and 27 amendments. What does it mean is that is what we call a synthetic constitution. It only establishes what we call negative rights in Brazil, the rights to be left alone, the right against state intervention. While just for a comparison analysis, our constitution, the Brazilian constitution, the 1988 federal constitution, it's our 7th constitution, 7th. Brazil started as a monarchy for almost 70 years, and then it was a republic and became a republic to a republic, and we had 5 constitutions. The 1988 constitution is about 250 articles and more than 100 amendments in a period of a little bit over 30 years. So what's interesting about the U.S. Constitution when you compare to the Brazilian Constitution is that it's a very flexible Constitution in the sense that the interpretation of its amendments adapt with time and circumstance. And also a very interesting difference is that since we have a 1988 Constitution, we have legislation that is prior to that 1988 Constitution, we have the phenomenon what we call acceptance, recepção, acceptance. So it means that you see if prior legislation made during dictatorial periods from Brazil, for instance, the new states from 1937 to 1945, Estado Novo, or the military regime from 1964 to 1985, have been adapted to our current constitution. So it's a different phenomenon. While the U.S. Constitution, all legislation is after the enactment of the U.S. Constitution, and the thing is whether this legislation will adapt with those provisions, and those provisions many times by judicial interpretation are adapted for new times. So we're going to take a look at that. But first of all, it's very important to say that out of these 27 amendments in the U.S. Constitution, 10 amendments came at once. They are the so-called the U.S. Bill of Rights. They are from 1791, and they are, for instance, the First Amendment that established freedom of expression, freedom of the press, freedom of association, freedom of religion. The idea that the U.S. you can pretty much say whatever you want without being prosecuted for that. Of course, there are some restrictions, for instance, in times of national security, and there are other issues at hand, but at least in theory, it is a country that allows freedom of speech uh, and freedom of the press at its highest level. Okay, the Second Amendment is the right to bear arms, which is a famous amendment, a very controversial amendment that have been expanded and broadened, and its view it's very controversial in the sense that you can bear any sort of arms, and even semi-automatics, and you see this what's happening in the United States in this sense. So it's an amendment that suffered different interpretations by the power of lobbies and organizations. Now you have broader view on that amendment. You have the Fourth Amendment was the protection against unlawful searches and seizures. Of course, no one can get into your house without a warrant, and nobody can seize your property without due process of law. You have the Fifth Amendment with the right to a jury trial, a jury trial by peers. This is very different from Brazil. For instance, in Brazil, we only have juries for willful crimes against life, homicide, manslaughter, attempted homicide, etc. While in the U.S., anything pretty much can go to a jury, especially on a federal level, but also state level, because state constitutions always predict this protection. The right against self-incrimination, like I said, also in the Fifth Amendment, is only for criminal cases. You've probably seen in movies. I'm going to take the fifth. I'm going to plead the fifth when I am in when I took the oath and at a witness stand or at a congressional hearing. So the right against self-incrimination, and the Eighth Amendment with the idea of excessive bail and fines, and that you cannot have excessive bail and fines and cruel and unusual punishment. Of course, that the discussion is whether the death penalty, the capital punishment, would be cruel and unusual punishment. And by recent interpretations, I mean, from the 70s, interpretations from the Supreme Court, such as in Gregg versus Georgia, it was decided that for certain types of felonies, particular first-degree murder, second-degree murder, I believe as well, but homicide, it can be applicable by states with certain regulations. So this is one observation that I would like to do, is that the U.S. Constitution is very much more broader. Sorry, the opposite. The U.S. Constitution is much more synthetic than the Brazilian Constitution, which is much more of an analytical constitution, in the sense that it presents several rights, obligations to the states, guidelines to the states, while the U.S. Constitution is much more open to interpretation. So what's cruel and unusual punishment? Is the death penalty cruel and unusual punishment? Is letting a person stay in the death row for 20 or 20 years, a convicted felon, a cruel and unusual punishment? While in Brazil, the Brazilian Constitution already lists that there is no death penalty in Brazil, that there is no life sentence in Brazil, so you can only stay 30 years in jail. So it's a much more analytical constitution than the U.S. Constitution. And of course, that while the U.S. Constitution only establishes negative rights, the so-called negative rights, personal liberties, individual freedoms, the Brazilian Constitution establishes, and it has a very strong list in in Article 5 establishing social rights like health, education, and also other sort of third generation rights such as consumer protection, environmental law, and so it's much more of a constitution that establishes guidelines to the government to how to perform its functions. Okay, so that's an interesting thing to observe. Okay, so one thing that I just said is that I said you have jury trials on a federal level by Article 5 of the U.S. Constitution, also Article 6 and 7 mention juries. But the thing is that I believe Article 6 also mentions juries, but the thing is that the Sixth Amendment, I mean, also mentioned juries, and the Seventh Amendment mentioned then on a civil level or civil cases. But the interesting thing to observe here is that the Bill of Rights was originally intended to be applicable, and the U.S. Constitution as a whole, only to the federal government. So states, they have delegated powers under the 10th Amendment. What does not belong to the government or the federal government belongs to the states or the people, respectively, under the 4th Amendment, the 10th Amendment of the U.S. Constitution. But by different judicial interpretations, certain protections have been applicable on a state level. And of course, the most famous case, this started, first of all, with Gitlow versus New York from 1925. But you have a case from the 60s, which is Miranda versus Arizona, which dealt with the right against self-incrimination and said that the Fifth Amendment protection against self-incrimination is not only applicable on a court of law, but also during police custody. So we created the so famous Miranda warning, Miranda rights, the right you have the right to remain silent. Anything you say can be used against you in the court of law. If you have a right to an attorney, if you cannot afford an attorney, the state will provide one from you. You've probably seen that in movies. This was brought with this Miranda versus Arizona case, and it's a case that had as a leading case a plaintiff, a defendant at the case because it was a criminal defendant from Arizona. So now some protections are applicable to the states, but not originally. The Brazilian Constitution is very different in the sense that you have, like in the U.S., you have the so-called congressional powers, the enumerated powers of Congress in Article 5, Section 8 of the U.S. Constitution. So, for instance, bankruptcy is a federal matter in the United States. Immigration is a federal matter in the United States because is listed as so in Article 6, 5, Section 8. Commerce among nations in terms of immigration, and bankruptcy is listed expressly as a federal prerogative of a congressional power to legislate on bankruptcy. But when you're talking about and what does not belong to the federal government belongs to the states, with certain exceptions when you're talking about concurrent powers, which are the powers of the federal government and states to act jointly. For instance, we're going to talk about that, but the 14th Amendment and, of course, the 18th Amendment regarding the Prohibition era, where alcohol was prohibited in the United States. You could have states and the federal government states could enact legislation on this topic. So sometimes states may have concurrent powers. Most of the times they have delegated powers. Okay. In Brazil, it's very different. So in Brazil, the Brazilian Constitution lists all the powers that the federal government has, the state government has, municipalities have, and the federal district have. So you have from Articles 21st to 29th, I think it gets to Article 30, all the powers of this federal body entities. Okay, so that's the different. Also think that a typical federalist, you have two federal entities, which is the federal government and states, while in Brazil you have the municipalities also as federal entities. You also have the federal district, which is a mix between municipalities and the state. So it's a much more concentrated federalism in Brazil. Of course, that changed uh, during our Republican period. So just curiosity to see the difference between the U.S. and Brazil. Brazil started as an empire with a monarchy, with the emperor of Brazil, and concentrated the decisions, although Brazil is a continental country, was concentrated in the emperor of Brazil. While in the West, the West started as a confederation of former colonies, original 13 colonies, wanting to fight against the British, and they joined in an international treaty, the so-called of Articles of Confederation, if I'm not mistaken. And after that, they decided to become federation, modern federation. They joined the union and became a sole country. So is a much more much less centered federalism, a counter-centered federalism in the U.S. While in the U.S., in Brazil, we were an empire. Then there was the proclamation of so we were a unitary form of government. Then there was a proclamation of the republic. The Republicans, along with the militaries, declared the republic in 1889. Something with a coup of staff with military support. So it became a republic, and during this period, this more than 100 years of Republican period and a federalist Republican period, we have dictatorial periods, we have more democratic periods. We have been in a democracy for more than 30 years now, and so we had periods of more concentrated federalism, of less concentrated federalism, but the federal constitution enumerates powers of states and municipalities. Of course, states and municipalities also have delegated powers, as in the U.S. Constitution. They also have residual powers to do municipalities do their affairs, but it's much more narrower because the Brazilian Constitution lists most of the powers that the states and the municipalities and so on have. Okay, so talking about concurrent powers, it's interesting that to observe that the 14th Amendment was a very important amendment. It was made after the Reconstruction. It was during the Reconstruction era, after the Civil War, when southern states tried to leave the Union. And of course, that what happened here is that first of all, they passed certain constitutional amendments after the Civil War, and the first 13th Amendment freed the slaves in the United States, right? And the 14th Amendment tried to give them equal citizenship. And the 14th Amendment is a very interesting amendment to understand judicial interpretation. It was originally made to enforce civil rights of African Americans, and so was mainly made, of course, to all citizens, but mostly to African Americans, in the sense of giving everyone equal citizenship. So establishes life, the right to life, liberty, property, and due process of law, as well as equal protection before the law. And it has been an amendment, and it has been an amendment that has been interpreted as this equal protection and among other protections to apply to women, gay couples, and other minorities that or other minorities that were not originally protected by the 14th Amendment. I mean, homosexuality was a crime until a few years ago, or a few decades ago in the U.S. Women didn't have the right to vote until the 40s in many states, in some states. So it is an amendment that was reinterpreted with time. And also, it's interesting to see that since this amendment is applicable to states, and states can establish concurrent legislation on the matter of this equal protection. And so it is uh, it is an amendment that was used to incorporate some federal protections as the Bill of Rights into states. So we have a theory, we're going to talk a little bit about that, but the idea of the substantive due process of law. So the idea that due process is not only in the court of law, but it's a matter of protection of certain protections to citizens, and those are incorporated into states as a difficult theory. But let me just move on for you to understand better. So just having a quick sip of a coffee here, Brazilian coffee. So we have the Declaration of Independence that establishes guidelines. It's not the same as the U.S. Constitution in 1776, and the U.S. Constitution establishes checks and balances. The idea of establishing a counterweight, a limitation on the powers of branches of government. So the idea of Montesquieu, the idea of Locke, you know, you have the idea of powers balancing each other. You also have this in Brazil, which we are also presidentialist system with some changes from the US, but this is a matter for another discussion. And also, of course, the idea in the US Constitution that we have also in Brazil of a House of Representatives and a Senate to balance the power of the people and the states. And these are very interesting theories that were adopted in many other countries, including Brazil. Adopted originally in the US from French thinkers, but then adopted with adaptations in other countries. Okay, so like I said, Articles 5th to 3rd establish the branches of government. There is a strong discussion of state powers within the U.S. Constitution under the delegated powers and what powers belongs to the federal government. So, for instance, you have the thing about the supremacy clause, the idea that the Supreme Constitution is the Supreme Court law of the land, and when does it prevail over state authority? Okay, and of course, the whole idea of the American Civil War was built on this idea that states, especially southern states, wanted to keep slavery, northern states wanted to abolish slavery or did abolish slavery, and how would be for new states under that Western expansion, how would it be for new states? Would they be free or would they be hold slavery and all of that? And so this idea of where the Congress, where the federal government can intervene versus where states have their rights to legislate on different protections is still very much different rights, family, and others is always a matter of hot discussion. And okay, I could skip that about common law and territory decisions, but it's interesting to observe. Just talking a little bit about Plessy versus Ferguson, which is a very famous precedent that was established in the United States. That first of all, it's interesting to observe that constitutional protection not necessarily means that there is going to be enforced. And the 14th Amendment established equal protection to everyone, equal protection before the law, and but it was very much tainted by different or get it. That's a good word. Get it by different decisions. So many decisions started to limit this equal protection, especially for African Americans. And so we had the slaughterhouse cases. I have a slide where they are mentioned, and we have finally the Plessy versus Ferguson case that establishes separate but equal, and officially established racial segregation in the U.S. and officially made Jim Crow laws, which were the segregation laws in the south of the United States, mostly constitutional. So the idea that you can have different wagons for people of different ethnicities. I don't like to use race. There is only one race, the human race, so different ethnicities. People from um, so different wagons, different schools, different buses, and all of that. So this was, of course, was overturned in this was overturned starting with the case in with Brown versus Board of Education of Topeka, and it's interesting to observe that this this was the land for uh, almost more than century. I would say that for more than 1 century, there's so much stuff here that we could talk about. Dred Scott, uh, Marbury versus Madison, but I mean, under the interest of time, we're going to move on. But let me see if I can find here. So the Reconstruction era. Okay, so here and then I move back. So like I said, this equal protection was not the law was not applicable because Congress did not enact legislation on that matter for more than 100 years, and the Supreme Court gutted or distorted this uh, protection with these cases here, slaughterhouse cases from 1873, and then Plessy versus Ferguson. So, and of course, that it was only in the 60s after Kennedy's assassination with Lyndon B. Johnson, his former vice president, and then who succeeded Kennedy, that he passed legislation such as the Voting Rights Act, the Civil Rights Act for 1964, the Voting Rights Act for 1965, and so on, and which, by the way, are protections that are now applicable not only for uh, uh, race, but also gender, sex, and all of that. So one thing that's very interesting to observe is that, and one thing that divides Americans and I mean, in terms of legal thinking, it's the idea of a constitutional right of privacy. So you had an idea that there was a right of privacy within the U.S. Constitution, with started with Greenwood versus Connecticut. There is nothing expressly set in the Constitution of a right of privacy, but with Greenwood versus Connecticut, which is a case involving contraception, the use of contraceptives in family planning, the U.S. Supreme Court established a right of privacy from the penumbrous emanations in the Constitution. So, for instance, the Fourth Amendment, the Fifth Amendment, and some other amendments and protections in the Constitution would give a right of privacy, and then this right of privacy would have been incorporated to the states by the substantive due process clause, so the due process clause in the 14th Amendment. So this brought a discussion on whether the federal government, the Supreme Court, could interfere in the state affairs, and it has been used a couple of times. So, for instance, for Roe v. Wade, the idea that there would be a right of privacy for women to abort, and their first trimester. This was later affirmed but changed with Planned Parenthood versus Casey from 1992, and of course now was overturned by Dobbs from 2022 under a new composition, a new, more conservative composition of the U.S. Supreme Court. And so many states who wanted to regulate on abortion, they cannot, criminalize abortion, they cannot do it. So, because there's a right of privacy to want to abort under this interpretation of the U.S. Constitution. This was also applied in large Texas, which involves sodomy laws for two consulting adults from the same gender, if they wanted to do, if they wanted to perform sexual activities or have sexual relations, there would be a sodomy laws in a few states, and most states already had changed that, but I think around 9 states still kept the sodomy laws for and included homosexuals, homosexual intercourse into those sodomy laws, and this was of course changed with Laws versus Texas, and more recently with Obergefell versus Hodges. I'm sorry if I'm not pronouncing correct, from 2015, which involves same-sex marriage. So this was a split decision, 5-4 decision from the U.S. Supreme Court. And because of that, some states that did not allow gay marriage would not issue a marriage certificate. Gay couples now are obliged to do it under this interpretation. So, of course, for conservatives, or especially for originalists, such as former Justice Scalia, and who has some successors in the new composed Supreme Court. This is a matter for the states to decide under their delegated powers within the 10th Amendment of the U.S. Constitution. So there is some ideas here. Let me just move on. We have not much time. We have some ideas here of different school of thinking in the U.S. Some of them are applied in Brazil as well. But for instance, you have the originalist thinking, the idea of the original intent of the Constitution, how the Constitution should be read as it was written, and this creates the idea of a bad Constitution, or as originally as Scalia, with his classical wit, would say, a enduring Constitution. And the other would be the idea of a living Constitution. And the idea of a living Constitution, you have the pragmatism theory, you have the judicial activist theory of expanding constitutional rights. This was very much done in the Warren Court, which, among other things, rule on Brown versus Board of Education, which we mentioned before. Judicial activists here, it's called in Brazil neoconstitutionalism. And you have different theories: textualism, structuralism, and all that. Strict constructivism, which is the judicial restraint. Many matters should be left to the legislators to decide, state legislatures to decide, or to Congress to decide. Natural law, which comes from St. Thomas of Aquinas, and we have now you have Gorsuch, I think that's his pronunciation, in the Supreme Court, which is a natural theorican of natural law. So you have different theories. I'm going to skip that. If you want those slides, please send me an email, and I'll be more than glad to share it with you. This is what I have to say. And just a comparison analysis, just quickly, in Brazil, you have see natural law here. But let me just put it in for you to have my information. So my name is Olavo Caiuby. My email olavo.bernardes@tv.org.pr, and this is my professional Instagram. So you can follow me. I'm an attorney, law professor, LLM in U.S. international law and legal English teacher. But just make a final analysis here. If you see the Brazilian Constitution, which was made in 1988, and much more, like I said, analytical. It does create a space for more judicial challenge, especially after the end of the military regime, and you have different interpretations of the Brazilian Constitution that have suspended certain rights. For instance, you have in Article 2026 of the Brazilian Constitution the idea of that family is between a man and a woman. This was made the National Constitutional Assembly in 1988, and it has been interpreted that should be expanded to gay couples, all sort of couples. This was made by the Brazilian Supreme Court, the Brazilian STF, Supreme Federal Court, not by legislators. So the judicial activism, when should you wait for Congress to act or state legislature to act, and when should courts intervene, or when there should be use their judicial restraint, not act politically, and so on. It's very much discussed both in Brazil and the US. So I'm just going to wrap it up and thank you so much for your time and patience. And feel free to contact me, and welcome to the World Constitution Day. See you later. Bye bye. Thanks. Obrigado.